Is that my cue? Or not?
Soon as the screen goes down.
Okay, thank you, Alan. I get it. Here we go. Good afternoon, everyone. Welcome to our next panel, following quickly on the heels of the last panel, the evolution of legal and political treatment of cities. We had a very good discussion, and in some ways, we're going to continue it and pick up on some of the themes that were raised in the last panel. It was a fascinating conversation, but with some new panelists. Ours is the history of cities in Canada. That's the title, and we're going to explore some of the history of the governmentalities, municipal corporations and other governmentalities in place in Canada, and mainly East and West Canada, as they were then called, and also a little bit of the history of the money and the financing and taxation that drove some of those things, or maybe were driven by some of those things. We're going to find out through our panel. I'll just quickly do some housekeeping and a land acknowledgement and give some very brief introductions of our distinguished panel, and then I'll get out of the way and I'll ask Mary Stokes to lead us off when we get there. But before I do that, I just want to do a quick land acknowledgement. I know it was done on the last panel, but sometimes these things change from time and place to place, but I'm still in Toronto, and I'll give the same acknowledgement that was given by the chair of the last panel. We're meeting on the traditional territory, at least those of us in Toronto are, of many nations, including the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, the Haudenosaunee, and the Wendat peoples. And Toronto is now home to diverse First Nations, Inuit, and Métis people. And we also acknowledge that we're covered by Treaty 13 with the Mississaugas of the Credit. So thank you. And with that, I'll just turn to some quick introductions. Actually, I should just quickly introduce myself. I didn't do that immediately. I'm Simon Archer. I'm a partner at Goldblatt Partners, which is a firm practicing in Toronto and Ottawa and in places around Canada. And I'm actually stepping into the very big shoes, which I cannot fill, of Sigma Dam-Shanks, who was originally meant to moderate this panel, but was called on to join a committee meeting helping to have input into the next Supreme Court pick. And so her voice is very much needed there as it is here and will be missed. But we're glad for her in her new duties. I'll do my best to stand in for her. Reading these long bios of distinguished speakers is sometimes a little bit like a eulogy. And so I asked everyone to just send me a sentence or two of what they'd like me to say about them before we started, and they all complied, and it was wonderful. So in no particular order, except the order in which we're going to hear from our panelists. First, we'll be hearing from Mary Stokes, who is a fellow legalist like myself, practicing in Ontario. But more importantly, Mary has an MA and a PhD in history and in law, respectively, and is a director of the Osgoode Society for Canadian Legal History and for the Canadian Foundation for Legal Research. And we're going to hear, I believe, comments, excerpts from Mary's dissertation on the history of municipal corporations in Ontario. And so we'll look forward to that. Then we're going to hear from Dr. Almos Tassonyi. I hope I said that right, Almos, and please correct me if I haven't. Who is the Executive Fellow and Director of the Urban Policy Program, and many of you will know him, at the School of Public Policy at the University of Calgary, and an adjunct professor of economics at Ryerson, and an adjunct lecturer at a number of other places as well that I won't list. But Almos has written a book on property tax reform and has done lots of writing and research on municipal budgeting, property taxation, and fiscal decentralization. And we're going to hear a little bit about the most recent piece of research that he's been doing along those lines as well. Then we're going to hear from Jean-Christophe Bédard-Rubin. I hope I didn't mutilate that, Jean-Christophe, and correct me if I did, who's a doctoral candidate at the Faculty of Law at the University of Toronto and the Joseph Armand Bombardier Scholar. I probably butchered that as well. Jean-Christophe explores Canadian constitutional cultures from a comparative perspective And I'm gonna deliver your thesis title, Jean-Christophe. It's a long one, but I'm gonna do my best with it. Claiming constituent authority in non-revolutionary constitutionalism, state sovereignty and representation in the formation of French-Canadian constitutional culture. And I think we're going to hear a little bit about your research along those lines, especially in comparative context with Mary's remarks earlier. So we're looking forward to that. And then last, but of course not least, someone who I do already know, and that's Mary Eberts. And she saved me the task of reading her wiki page by sending the following along. A lawyer, just most humbly, a lawyer working in the areas of constitutional law, equality rights, and Aboriginal law, was humbly involved in the advocacy that led to the final draft of the Charter of Rights and Freedoms, was counsel on the team for the Federation of Canadian Municipalities in the Court of Appeal and Supreme Court proceedings in the challenge to Bill 5, which we discussed briefly in the last session, and I hope we'll talk a little bit about in the challenge today. Mary's also a senior fellow at Massey College, and will be delivering, I believe, some remarks based on the submissions that she made to the Supremes. It was about 2 weeks ago now, I think, urging them on an interpretation of Section 92.8. So last little bit of housekeeping and I'll stop talking. We have a 90-minute panel, so it's a little bit longer than the last one. We have 4 15-minute presentations or so. I'll try and be a bit strict in calling time so that we can get a full 20 or 30 minutes of questions and answers when we get to the end, because I think there'll be a bunch accumulated from the previous panel and this panel that will all fit nicely together when we get our comparative context going. Last thing, please, therefore, because we're going to hear from our panelists for about an hour before we get to questions, please write down your questions and keep them. It's a bit of distance from the first to the last. Write them in the chat if you like, and I'll moderate or send them to me, but please write them down and keep them so that we can queue them up and have a good discussion at the end of our first hour. Okay, without further ado, Mary, would you like to kick us off, please?
Yes, am I unmuted? Can you hear me? Okay, good. Thank you very much, Simon, and thank you, panelists. When I first came in, I mentioned that I almost withdrew from this panel because I have been having some health challenges with regard to my inner ear situation and sinuses, and I'm totally hopped up on drugs at the moment. So I may not be making a lot of sense. Well, I don't make a lot of sense anyway, but I will not be reading from my dissertation. So that's a blessing probably. I did want to talk to you about some of these issues because I have been researching and thinking about urban autonomy, municipal autonomy for a lot of years. And I think I have a few reflections that I can share with you. So the theme of the conference, constitutional space for cities. I thought some of the things that I could talk about are, why do cities not have constitutional space in Canada? And the reason does relate to our history. That does not mean that we should be stuck with what we have, but it helps, I think, to understand why we're in the situation we're in. So as Mary will be telling you, and you may have heard earlier in the day, municipal institutions are the purview of the province under the Constitution originally of 1867. If you read the Confederation debates, there was very little mentioned about municipalities. It was just not an issue for them. The reason it got given to the province was that under the Union of the Canadas, Canada West and Canada East, from prior to Confederation, they had a legal union, but functionally speaking, they divided their jurisdiction in some areas. Municipalities were one of them, and education was another. So the understanding was Ontario or Canada West will legislate for Canada West, and Canada East will legislate for Canada East. You can still vote for the various laws, but the responsibility is for that area. The same thing with education. Ontario did not try to, at least not very hard, to legislate for Quebec. And there were a few other places. But anyway, they just pretty much continued on the way things had been. And several people asked me when I announced that my dissertation was going to be from 1850 to 1880, well, what about Confederation? Well, in fact, Confederation had very little effect on municipal affairs, at least in Ontario, except that it froze them. It's a constitutional moment that froze the way things had been and made it difficult to change things, as we will hear from Mary and Simon later on. So why do cities not have constitutional space? At the time, there were certainly cities. There were cities in the Maritimes. There were cities in Quebec and Ontario that preceded Confederation, and in fact, the Union of the Canadas. But by the Municipal Act in 1849, they made several changes, and I think that Jean-Christophe mentions the expansion of the elective principle to the lower level of municipalities, instead of having appointed heads of the local government. But really, I think the prominent feature of the Municipal Act was its comprehensiveness. And this was sui generis. It was not taken from anything in Great Britain or in the States. Great Britain had a Municipal Corporations Act, but all that did was really establish a template for corporations that will be made or that are already made. They didn't change most of the municipal law in England, which was justices of the peace. So the big change was that everyone had to be in a local government, every acre, with one very interesting exception, which we will talk about later. So you were either living in a township, a village, an unincorporated police village, police meaning regulation, not surveillance, and a city, a town. They were all lower tier municipalities, meaning that they all were to come together as part of a federation. The federation would be the county. So the county didn't have original jurisdiction, basically. It was basically all of the heads of the lower areas would come to the county council, and they would set a county rate and supervise the collecting of taxes at the lower level, including cities, and then decide how much everybody needed. But they were told by the province how much to send to the province. The property tax was the greater part of revenue for the province for a long time. The only other, at this time, the only other sources of revenue were customs, which were collected at Quebec, and which Upper and Lower Canada had been fighting about for a long time, and selling licenses and selling crown lands, but mostly it was from property taxes and also from income taxes at the municipal level. We don't hear too much about municipal taxes because they had a heck of a time collecting them, and perhaps Almos will talk to us about that a little bit. The only people they could collect income taxes from were people who were on the civil list. That is, they had a job as the customs officer for the harbor, and their salary was a matter of public record. So they couldn't get away with telling the assessment officer that they didn't have any income. Everybody else could. So things were kind of frozen in 1867. Not much changed. Now cities, as I said, they were just one of a bunch of local governments. Cities were allowed to withdraw from the county, from the federation, if they wanted to, and so were towns later on, and a lot of them did that. Not particularly because of power, but because of money. They didn't want their money to be spent by someone else. Fair enough. But the cities themselves didn't have any more constitutional status than they had had before as a town or whatever. The counties were important because they drove the economy. It was a rural economy. The cities were the market centers, trade. Later in the century, the time that Almos is going to talk to you about, cities and towns became a greater share of population. It's kind of difficult, though, to tell how many people were living in cities as opposed to countryside, because they considered urban, even little tiny villages were considered urban. So if they say 50% of the province is urban, that does not mean that people were living in cities. It wasn't until after the First World War that more people were living in cities than in the rest of the province. And we're also only talking about the southern part of Ontario at this time. But within southern Ontario, everybody was in the local government, except for one exception. And as I said, I will stress this because I think it's quite important. The First Nations, who had reservations in Ontario, were not included in the Municipal Act, the municipal system. When I defended my dissertation, one of the examiners, a historian, asked me why I did not include First Nations with the local governments that I was discussing. And there was two reasons for it. First, because they were specifically excluded from the municipal system by a companion act. But more importantly, they're nations. They're not local governments. And their legitimacy derives from their sovereignty rather than the other way around. Their sovereignty derives from political theory and international treaties. The UN Declaration of the Rights of Indigenous Peoples. Whereas in Canada, we do have this dissonance between the idea of democracy, and in some ways, municipal governments were more democratic and have always been more democratic than any other governments. They had lower property qualifications, and they had, women were allowed to vote who were property owners earlier than they were as citizens. So municipalities kind of led the way in a lot of democratic reform, but they didn't have any sovereignty, as you will hear, and they were creatures of the province, which was a term that was taken from Judge Dillon in the States, who wrote a very famous treatise on municipal corporations in the 1870s. And he said that municipalities were creatures of the state, and he has been very influential in municipal law and history since then. So what else can I tell you? Because there was this exception made for First Nations, there is a space, I think, for cities to say, not everybody is the same. Look, you made these exceptions for First Nations who are also, you know, able to vote and whatnot. Perhaps there is room to have a paradigm shift as far as urban areas go. Part of the reason why they never did this before is because the urban areas were always at each other's throats, competing for everything. It was very difficult for them to get together and consider that they had interests different from the province. Mostly at this stage, they were all pretty homogenized settler people, and they all wanted the same thing. They wanted growth and more growth. And as individual cities, they wanted their growth at the expense of the growth of the municipality down the road. What else?
I'll just prompt you for a 2-minute wrap up, Mary, when
Yep,
you, yeah.
I hear you. So I guess I don't have too much more to say. The Municipal Act was constitution-like, and we never had the state constitutions the way they have in the States, which were constantly being amended, and are where the home rule idea came in. They were a constitutional state issue.
Is that a good place to land?
Okay, I think that's it.
Oh, that's great. Thank you very
So
much.
thank you for listening to me.
Thank you for kicking us off. I've got already 4 or 5 questions. I'm writing them down, and I'm going to hold them for you. I promise to get to. But next, we're going to hear from Almos. Can you take it away? Are you ready to go, Almos? Excellent.
Yes, I'll share my screen. Hopefully that works. If I can get to it. Okay. So first of all, thank you very much for inviting me. I won't attempt the full land acknowledgement this morning because I'm actually in Toronto, so as opposed to the institution with which I'm connected. And I also, while Simon's introduction was very flattering, my co-authors on the book on property tax were Richard Bird and Enid Slack, and they did most of the serious work on the project. This paper is also an outgrowth of a dissertation as well, and part of it is really it is more skeletal than the papers and the presentations that you're likely to hear from and have heard from Mary and Jean-Christophe, but it is skeletal because this is an area with which very few people have actually spent any time looking at what the trend lines were and what was happening in terms of municipal finance and the structures of municipal finance. The background motivation some time ago was when I was a Cal Young undergraduate, I had the Dians of Canadian economic history. And Tom Easterbrook told me that the trouble with Canadian economic history was that there are too many architects and not enough draftsmen. And then when I was casting around looking at dissertation topics, Ian Drummond said, well, there are far too many Canadian economic historians hiding behind the fur trade. And at that point, I was looking at, actually, to tell the truth, agricultural development in late 19th century Ontario, but I kind of kept on running into these fascinating sessional papers related to municipal finance. And then I spent far too much time working at Ministry of Municipal Affairs and Municipal Finance and thinking about some of these issues. So the typical motivation for looking at this topic is, why should we really worry about local public finance? And of course, we all know the standard story that when you wake up in the morning, you brush your teeth, you walk out on a sidewalk, you may drive on a road, or you may take a transit bus. These are the kinds of things that we tell students as to why we should worry about local public finance, because it finances all these local services. But the economic history of local public finance in Canada has largely been neglected. There is, in fact, not much by way of, there are scattered papers on the overview of Ontario municipal finances and its relationship to education finances. Certainly by comparison to the American literature on these topics, ours is very limited. There are also, of course, the vicissitudes in the provincial-local fiscal relationship, and as well, to some extent, the federal one. And Mary Eberts' presentation comes to that later. So some of this is really a matter of looking at some of the patterns of the revenue base, taxation, expenditure, and borrowing, with municipalities as being the principal public goods providers. And there are also questions about whether they grew into or ahead of a revenue base, as some more recent critical views have been taken on the current state of municipal finances and burdens of the property tax. And so we also have issues around the impact of urbanization on tax base and expenditures, provincially considered whether constitutional or other constraints on tax levels, on assessment methods, and borrowing constraints. So these are multiple questions in their area. I'll skip over this, the principal literature other people may want to explore. This paper was written in parts before the more recent work by Elspeth Heeman and Shirley Tillotson on the development of the income tax. And it is, one of the defects in it is that I don't bridge back into the work of Michael Piva and the period where the public finance that he's looked at in the Canada is an important contribution, but actually bridging between the pre-Confederation to the post-Confederation, and then a couple of decades later, is actually one of the posing empirical difficulties in this area. And not to be beaten up by the many people talking about the orders of government, but as my friend Emery noted in a 2003 paper, the creatures must be fed, and that led us to a discussion around taxation and borrowing and so forth. And John Wallace, in the American context and the development of the American fiscal situation, talked about normal taxation, benefit taxation, and taxless finance. It's something for everyone. Is some of the underlying ways of thinking about and or organizing the intergovernmental and the assignment of taxation. So there is, in some sense, that. Now, Mary alluded to the issues around the population distribution in cities, and our cities in this context and urban city populations, as you can see here, the growth period is really more protracted after 1910 or so. If you can see this graph on your screens, the rural share is falling over time. These are based essentially on the census definitions. And so cities are the approximately 30 or so larger municipalities above 5,000 that were politically organized as cities, and for the sake of this argument. But if we go back to the Confederation arguments, and as Mary points out quite correctly, there are very little alluded to. The province has got the unpopular direct taxes and certain licenses, while the Dominion was to be let to without hindrance in its taxing rights. And essentially, one of the nicer statements that were made by, I believe it was Galt actually at the time, was that if we force people to confront the use of direct taxation and to use those funds for administering local affairs, then they will pause before any career of extravagance. And so the whole issue of extravagant municipalities and their spending, which is often a common shibboleth that is repeated in current circumstances, was already being voiced at that time. Now, this graph is to show you really the principal point that municipal debt, which was issued and used as a means of funding infrastructure from the beginning, for when at least reasonably good numbers exist from about the mid 1880s, increased steadily in terms of the dollars of the day, but really was only overtaken by the provincial debt after the First World War, in and around 1925 or so. And it is with the Depression and certain other events, which I will mention later, that the municipal debt totals actually were significantly reduced. Municipal taxation, in fact, outruns in total in the province provincial gross revenue, just to give you some idea as to the importance and the size of the third order. And this table also tries to point that out. These are again in the current dollars of the day. But if you look towards the bottom of the graph, and then from 1926 to 1941, and you can see that there's a peak in the totals of local tax imposed in 1931, and then the crisis really happened, and municipalities had to reel in their taxes, whereas the provincial taxes continued to rise. And the estimate of Ontario share, which is from Raul Sirois, shows the general importance of Ontario in the total federal picture if you compare the last two columns quickly. Now, these numbers I don't want to bore you too much, but just to sort of point to some highlights. If you look at local taxes as compared to provincial taxes, from the beginning on a rough basis, local taxes only really equal the total of provincial taxes being imposed in the middle of the 1930s. And local debt issued for infrastructure financing and for other things was far more significant in the capital markets than provincial debt was until the 1930s. So these are interesting fiscal points that are often lost in terms of the importance of municipal governments in the fiscal development of the province itself. Now, municipal expenditures are somewhat of the weaker numbers that exist, and these are in 1900 dollars. Again, it is really just to highlight the point that you have a fairly consistent growth in the responsibilities and in municipal expenditures on roads and on infrastructure and on providing the basis for urban living until the middle of the Depression, when these constraints happened. And the functional shares also show, but I don't think I'll spend too much time on this table, other than to really see that it is only in the 1930s that you have the substantial implications of having to up expenditures on relief and on charities, and by contrast, a considerable reduction in spending of shares of roads and on general government. Now, having said all that, the principal expenditure pressures in the post-World War I period, of course, come with the automobile infrastructure, with essentially growth or sprawl, if you like, and education as an expenditure predicated really on local resources. Subsequently, we've got the Great Depression, relief and pensions, and elsewhere. I plead guilty to having written on the issues around supervision by the province of municipalities and the bankrupt municipalities, and Mary Eberts' paper alludes to some of those restructurings that were happening in the 1930s as early examples of provincial intervention. But returning quickly to the pictures here that I have at hand, again, here, one of the things one should point out, of course, is that real property was a substantial underpinning for the municipal fiscal base. And personal and business and income was part of the municipal fiscal base, but was not so significant. And again, in this particular picture, you just have a picture of the changing share of real property assessment by type of municipality. So I think I will go past effective tax rates. That's not too critical. But here on this picture, the school shares, the urban school share is the light blue at the bottom of the screen, and city municipal is the beige line, which really shows you how cities essentially became far more important in terms of the mix of where taxation was happening over the period between 1911 and 1941. And to some extent, that peak that you see in the 1930s represents a part where, in fact, the tax burden added to the issues faced by municipalities in the 1930s. Okay. So, and we have also an idea that, in a sense, that effective local tax rates were also increasing, in part reflecting the needs and the continuing needs of municipalities through this time period as well. Okay, so I'm coming towards the end of this, but one of the points that should be made was, in fact, municipalities did have access to the income tax up until 1937, but the HEPBURN government at that point really was very concerned about what was happening within the municipal income tax, and certainly was one of the reasons why this particular tax field is taken away from municipalities at that point in time. The interesting thing about the municipal income tax, though, was that when municipalities got into trouble in the 1930s, there were certainly municipal experts that actually advocated that one of the problems was that they didn't have a diversified taxation, access to taxation field, and that Windsor in particular, which got into serious trouble in that time period, should have actually diversified using the municipal income tax that was available to them. Now, I haven't spent a lot of time in going back through the changing situation of that Mary alluded to. In the 1870s, the system began with taxation that was built on personal property as well as real property, personal property being horses, carriages, and stocks and bonds and so forth. And the dissatisfaction with the collectability of those taxes resulted in shifting the municipal tax base essentially to real property and to income taxation. And the paper, which may come later, it has more details on the processes by which those changes were made. Now, before I leave this completely, we of course are in the midst of a COVID pandemic and fiscal crises, and people ask, well, what happened in the last one? And so just to give you a picture of what happened with municipal debts, the total municipal debt picture really ends up, the gross total peaks out in the 1930s, and that really is a result of municipalities pulling in their horns, issuing less. 30 municipalities were put under supervision, and so you definitely have increasing debt up until the mid 1930s, and then a decline in the local debt picture as well. So the real conclusions in all of this are that there was a pocketbook impact, and more recent writings by Elspeth Heeman and Shirley Tillotson have emphasized that point, that there were other political pressures going on in the whole issues around the municipal tax base. There was also changes in the urbanization and institutional structure, and there was provincial intervention when municipal fiscal capacity was impaired, particularly in the midst of the 1930s. The outstanding feature in all of this essentially was, however, the capacity of the real property tax to finance municipal services, capital, and so forth. And a huge unknown and unresearched area is, in fact, the roles of municipal utilities and how that added to the fiscal picture. So I think at this point, I will stop, because
That's a good place.
a very skeletal look at, and there are a great many other issues that one could consider, including the relationship between the federal government, the provinces, and municipalities, particularly in responding to the fiscal pressures of the later period. So,
Thank you, Almos. That sounds like a good place to land. And thank you for the deck, which is very useful, especially with all the figures and trends. It's useful to have something visualize the empirical evidence that you were leading for us. Okay, shifting gears a little bit then. Jean-Christophe, are you ready to present? And it looks like you have a deck too. Okay, kick it off.
Just want to make sure that I do this correctly.
Sure.
Okay. Is that
Take your
fine?
time. Yep.
You can see that?
Ça marche.
Excellent. So, well, thank you, Simon, for the introduction. It's nice of you, these kinds of words, and thanks to the organizers for having me as well. It's really a pleasure and an honor to be sharing a little bit of the spotlight with such a distinguished group of speakers. And it's nice to see familiar faces and names and less familiar ones as well, because I'm standing here in Montreal, which has been a meeting place for peoples across Turtle Island and the Atlantic world for centuries. So it's nice that it can still provide this kind of venues today as I'm speaking to you, even though only virtually. So what I'd like to talk about is a bit of a spin-off of my doctoral dissertation that came as I was looking to mid-19th century French-Canadian constitutional culture. And as I was zooming in on this pre-Confederation era, I came to realize that there was kind of one piece of the puzzle that didn't quite fit, that there was one element that I didn't see on the intellectual maps that had been drawn so far by legal and political and constitutional historians of that period. And as you can guess, I'm sure this piece of the puzzle was municipalities. Now, there are two ways in which municipalities have been pictured generally in that period. They're either seen as new tools of a new kind of governmentality in a kind of state building enterprise, generally seen as utilitarian instruments for a new and well-oiled state machinery, or they're seen as tools for the development of a liberal civic culture, to instill, in a sense, a kind of character necessary for British subjects to be good, self-governing peoples. Now, what I came to realize is that there might be a third way of looking at the history of municipalities, as there was a form of back and forth between the reality on the ground and the imperial projects. That as they were exchanging arguments, British and French Canadians came to the conclusion that there had to be some form of mutual adaptation, and that municipalities kept coming up as a form of constitutional whack-a-mole, and that they were performing in the end two things. They would be necessary to secure institutions that would allow for responsible government, but that also some things had to be addressed for them to perform this crucial function. and to respond and fit more harmoniously with other principles of the British Constitution, such as no taxation without representation or delegatus non potest delegati. And it's this history a little bit of the back and forth that I'm trying to tell, and that I would call constitutional. And I would argue that this history allows us to see, in a sense, why in 1867, when the drafters of the BNA Act wrote that they wanted a constitution similar in principle to that of the United Kingdom, they had in mind that to achieve this, they needed elected municipalities boldly exercising their taxation powers. Now, the place to start this story is definitely with Durham. So Durham arrived in Canada in 1838. There had been rebellions in Upper and Lower Canada in 37, and he tried to address the constitutional discontentment of Canadians. But one of the problems that Durham saw is that both municipalities were not working properly and the legislative assemblies were not working properly either. And the problem was that members of the legislative assemblies that were sent to do the kind of business that the House of Commons would have been doing were actually only attending to local matters, securing as large an amount as possible of the general revenue of the province for local expenditures, roads, bridges, or as Durham would say rather contemptuously, mere parish business. So this was kind of a problem because Durham's solution for the Canadas was to suggest more self-government, insofar as it was compatible, obviously, with the British Empire. But this self-government could be achieved only if two institutional reforms were carried on. The first was the Crown having control over money bills, and the second would be municipal taxation. Now, these two elements fit together, actually. They're very important for Durham, because for Durham and for, I would say, the British Whigs at that time, responsible government meant party government, which means that in order to have a well-functioning assembly, you would need to have, on the one side, Her Majesty's government, and across the aisle, Her Majesty's opposition. And to have this kind of political cleavage between the executive and the opposition, you would need to have clear points at which the House would be controlling the activity of the executive, and there would be a competition for executive office. And this would be done through, for example, through the threat of withholding withholding assent to money bills. Money bills or budget would become votes of confidence later on, and they're a classic feature, in our minds at least, of what a Westminster system is. But to do this, members of the Legislative Assembly had to be distracted from attending to their local, small local constituents' concern. In a sense, there had to be a way of severing or of cutting the umbilical cord that tied members of the legislative assemblies from their local constituents. And this was a task that municipal taxation would be doing. In a sense, by generating local revenues and expending and spending these local revenues on local matters, they could allow the formation in the assembly of broader and more general political coalition that we would call political parties nowadays, and that could compete and form these broad-based political cleavages necessary for responsible government. Now, this was crucial to Durham, and he wrote it quite explicitly, actually, in his report. So he wrote, I'm just moving this around a little bit. Okay, so he wrote in his report, for example, if the rule of the Imperial Parliament that no money vote should be proposed without the previous consent of the Crown were introduced into these colonies, it might be wisely employed in protecting the public interests now frequently sacrificed in that scramble for local appropriations, which chiefly serves to give an undue influence to particular individuals and parties. Now, parties has a slightly different meaning here. But the key is that to establish the establishment of a good system of municipal institutions throughout these provinces is a matter of vital importance. The two things are intimately linked for Durham. And indeed, Durham's vision was actually taken up when Lord John Russell introduced the Canada Bill that would become the Union Act of 1840. He said in the House of Commons that it was proposed in conformity with our own constitutional views and maxims, that money votes should not originate with the Assembly. This was crucial, taking up the first part of Durham's report. But, he said, it was important to set up municipal institutions because, as he said, they proposed in another part of the bill to take away the power of originating money votes from the Assembly. This because is crucial. To Russell, like to Durham, municipal taxation was necessary if the main tool to achieve responsible government, which was executive control on money bills, were to be put in place. Unfortunately, the second part of the project was not enacted ultimately. There was resistance actually in the House of Commons, and some British merchants who were landowners in Lower Canada specifically feared the idea that self-governing local institutions or municipalities could siphon their wealth for local expenditures. And indeed, these kinds of complaints had been recurring because they were debating at that time a kind of municipal reform also for Ireland. And the kinds of concerns that they had for Irish Catholics were also in their mind for French Canadian Catholics as well. So ultimately, Russell decided to leave aside the provision regarding municipal institutions. So what happened is that the new governor was tasked with the mandate of establishing municipal institutions, which he did with executive proclamation. But there were problems with adopting a municipal scheme in Lower Canada with executive proclamation. The ink was not even dry on the executive proclamation that the imperial rubber hit the road. There were cries, beware taxes, these are taxation machines, and all kinds of constitutional claims were used, and British constitutional principles mobilized against the imperial project. Now, these relied on two kinds of constitutional principles. The first was no taxation without representation, and the second is delegatus non potest delegare, the idea that a power that had been delegated could not be sub-delegated if it was not specifically provided for in the first delegating act. And these two constitutional principles were kind of mixed together in many kinds of a little bit eyebrow-raising claims sometimes. But at least they tell us they're informative of a kind of constitutional grammar that was emerging at that time as Canadians were trying to build the conventions of responsible government. So for example, three kinds of claims that were made. The first kind of claim would be that municipalities can tax only if they've been given this power by representative institutions that themselves have this power to tax. An idea, for example, that the Crown prerogative could not set up corporations that would have taxation powers. It could only be done through an act of Parliament, or, for example, in the Canadian case, through an act of the legislature. Another example was that municipalities could only tax if they themselves were elective institutions. Those who were to decide taxation rates could not be appointed by the executive. Or another argument was that since there was no specific provision in the Union Act about municipal institutions, the legislature had to exercise its taxing authority itself. It could not sub-delegate a power that it had been delegated from London to municipal institutions that were not specifically provided for in the Act of Union. Now, these three kinds of claims kept recurring throughout the period of the Union from 1840 to 1867. And they created, they put a lot of pressure on the Consolidated Fund. What happened was that the grievances of Upper Canadians about the undue political influence of Lower Canadians were actually a way of criticizing the ethnic redistribution of wealth that was going on. Now, the work of Elsbeth Heeman has been already mentioned, and she shows very well that the complaints, for example, of people like George Brown about the undue influence of French Canadian Catholics were a way to protect Upper Canadian wealth from Lower Canadian tax avoidance. Local expenditures in Upper Canada were paid with local taxes. They were paid with the Consolidated Fund in Lower Canada. Jurymen, for example, were paid with local taxes in Upper Canada. They were paid with the Consolidated Fund in Lower Canada. And this Consolidated Fund consisted mostly of customs and excise taxes paid by more affluent Upper Canadian consumers. So there was really an ethnic redistribution of wealth because municipalities in Lower Canada didn't manage to generate the kind of revenues that they were expected to generate. Now, this was clearly on the minds of the drafters of the BNA Act. And Mary Stokes is right to say that there's not much about municipalities in the debates themselves. But I think that we can learn something when we keep an eye on the debates that have been going on for almost 25 years and the kinds of arguments that have been marshaled against municipal taxation in Lower Canada. Now, people like Alexander Galt, for example, kept saying the kinds of things that Durham and Russell had said, that municipal institutions were necessary if there were to be broad political cleavages and well-functioning parliamentary institutions. But to do this, the problems that had been created by the fact that the Act of Union didn't mention municipalities, these problems had to be addressed. And I think that this is part of the reason, at least. It's certainly not the only story that can be told, but it's one story that I think captures part of the reality on the ground behind Section 92.2 and 92.8, which provides that provincial legislatures would have direct taxation powers and that they would have power in relation to municipal institutions in the province. Because at that time, it wasn't clear what the nature of the powers of provincial legislatures would be. Did they have inherent powers or did they have delegated powers from the federal parliament or from the imperial parliament for that matter? It's only a couple of years later in the 1880s that these matters would be settled. But to the drafters of Confederation, it wasn't clear what the nature of the powers of the legislature would be. And if they were to have delegated power, they had to put into the bill specific provision to make sure that they could create institutions that would perform the vital task necessary for there to be well-functioning parliamentary institutions. And this is the reason why I think that to the drafter of the BNA Act, it can be said that it would be very hard for there to be a constitution similar in principle to that of the United Kingdom without municipalities boldly exercising their taxation powers. Thank you very much.
Thank you. That's fantastic, Jean-Christophe. That's a beautiful encapsulation and an excellent deck to bring it along. And I see it started some questions going back and forth in the chat as well. We're running just a little behind time, but we do have plenty of time for our final speaker, Mary Eberts. So Mary, I know we're just turning on the half hour, but we have a full half hour to go. So please don't truncate your remarks and give them all to us. I'll just get out of your way. I'm sorry. Are you ready to go?
Yes, now I am.
Okay, great.
My presentation is about the argument which our team of lawyers and law students put together for the Federation of Canadian Municipalities before the Ontario Court of Appeal and the Supreme Court of Canada in the case of Toronto versus Ontario, which entered the legal system when Ontario Bill 5 crashed into the Toronto election of 2018 when it was just half over. We did not participate in the argument that was the predominant argument in that case, namely about the application of Section 2 of the Charter relating to freedom of expression. Rather, we were looking for a narrower focus. And so we were concentrating on the power of the province to do what it did. It's a not entirely a jurisdictional argument. Let me tell you how that turned out. The City of Toronto was arguing that the principles, the unwritten constitutional principles of democracy and the rule of law would on their own prevent Ontario from interfering with the municipal election. We did not endorse the idea that the unwritten principles of the Constitution would have that much effect by themselves. Rather, what we said was that the principles would have an influence on the interpretation of Section 92.8 and what it guaranteed to the province, what it gave the province to do. And our focus within that argument was, again, quite narrow, because we acknowledged that the province could interfere with what we called the architecture of municipal institutions. That is, it could merge them together, it could do various things like that. But what we did say was that the province could not interfere with elections. And of course, at this level, dealing with Bill 5, interference with elections might be regarded as relatively modest. But for example, in the Court of Appeal, the lawyer for Ontario said that Ontario had such plenary power that the province could declare that the premier himself was the ruler of Toronto and then would abolish everything, all the other democratic processes. And then, of course, the question lingers, what if elections were abolished altogether by the province? Do they have the power to do that? So what we decided to do, because of the danger of allowing provinces to interfere with elections, municipal elections, was to argue that Section 92.8 of the Constitution had to be interpreted in accordance with the text and the context of the term, and the context would include the historical context. We did not have as much to support this argument in the Court of Appeal as we eventually did in the Supreme Court of Canada, because we did quite a lot of research between the Court of Appeal and the Supreme Court factums. But the gist of the argument was the same. And in the interest of time, I'm not going to tell you what we said at both courts. I'm just going to go to the argument that we made in the Supreme Court of Canada. And this is really twofold, both about the text and about the context. And the two are related. So we stated, or we argued, that the history of democratically elected municipal councils is as firmly related in Canada as it is in the UK. And in the UK, it goes back to the Charter of the City of London in 1067. In Lord Durham's 1839 report, he spoke extensively of the need to establish elected municipal councils as a means of ensuring the future success of the provinces. And we put before the court two extracts from Lord Durham's report, because we thought that the language was significant in light of the language of Section 92.8, where he said, "The utter want of municipal institutions may indeed be considered as one of the main causes of the failure of representative government and of the bad administration of the country. People should have been entrusted with a complete control over their own local affairs and been trained for taking their part in the concerns of the province." And then he continued at the end of his report to say, "The establishment of a good system of municipal institutions throughout these provinces is a matter of vital importance." And so we picked up on that and noted that between the date of Lord Durham's report and Confederation, there was throughout Canada the establishment in a rather speedy way of democratic local governments. And we pointed out that Toronto's council was democratic from the day of its incorporation in 1834, and also somewhat impishly that democracy was thriving in Kingston, which was incorporated in 1838. And in fact, Sir John A. Macdonald was elected to the municipal council there in 1843. Ottawa was incorporated as Bytown in 1847. And then in 1849, the Baldwin Act abolished the last of the provincially appointed wardens, leaving only one form of local government in Canada West, the Democratic Municipal Council. And so we argued that this rapid, deliberate trajectory towards universal democracy at the local level must be taken as forming part of the knowledge and experience of the framers of the Constitution Act. If we anchor the analysis of 92.8 in its historical context, the democratic principle expressed through the exercise of local democracy and the municipal election process lives within subsection 92.8 of the Constitution Act. And so that basically was our argument. There is a lot more to it, but that's the essence of it. And what, as I said, we didn't make as elaborate a reliance on the history in the Court of Appeal. And the Court of Appeal ruled against our point. All five judges ruled against our point. They basically said that while the principles, this is what the majority said, while the principles can be used as an interpretive aid to resolve genuinely open questions of constitutional and statutory interpretation, to address oversights or slips by the framers, or to determine jurisdiction over a new subject matter that has emerged since Confederation, they cannot be used, and this is the Court of Appeal language, and it shows you what they thought of the argument. They cannot be used to inject a new provision into 92.8. The Court of Appeal found that 92.8 does not constitutionalize any particular form of municipal governance and does not mandate or preclude particular institutions. 92.8, it said, is a general grant of lawmaking authority to the provincial legislatures, and it pointed out that municipal institutions lack constitutional status. So what we were trying to do with our argument is more or less in keeping with the title of the conference here, find constitutional space for cities. And the constitutional space that we were trying to protect was rather small. It was the democratic election. Although we have to acknowledge that had we been successful in breaking open 92.8 in that way, there may have been other ways of squeezing it open as well. But that was our main goal. And when we went to the Supreme Court of Canada, the emphasis again was on Section 2 and the argument on the Charter of Rights. And there was very little oral argument about the principle of democracy on its own, although it was plain to tell from one of the judges, Justice Brown, that he was not fond of the argument that the principle alone would protect civic elections. He called the principle bibbity bobbity boo after something in The Wizard of Oz. So we knew that he was not firmly convinced of its utility. And generally in the oral comments of the court, they were not comfortable with the idea that principles of democracy or rule of law would assist in themselves to strike down Bill 5. As far as our argument was concerned, that this the principles, particularly the principle of democracy, was interpretive, which is an allowed purpose for principles. We have no idea what the Supreme Court of Canada thinks of that argument. We hope that they will at least leave it alone and not say that, as the Court of Appeal did, that it was worthless, or say further that there was no constitutionalization of any particular form of municipal governance. Our contention was that there was, to a certain extent, constitutionalization of a part of the form of municipal governance, and that was that it should be elected. And so we are awaiting the reasons of the Supreme Court of Canada. And, you know, we know that from this point of departure, from the kind of argument that we have made, there are many other questions to arise. And for example, was the debate at Confederation, to the extent that there was one, about the raising of revenues or other municipal purposes, did they just take voting at the municipal level for granted? And here I think this is where some of the research that's being done on Lower Canada would be helpful, because admittedly our factum took Canada West as its gigantic example and did not look at the history of Canada East in as much detail. And so that's where we stand, trying to make a bit of constitutional room for what we regard as a very important aspect of civic culture, and that is its democracy, because of the harm to democracy and to municipal institutions that would result if the Supreme Court of Canada were to say that the province has unfettered jurisdiction to interfere with democratic elections at the municipal level. Thank you.
Thank you, Mary. What a good summary. The direct quote from Justice Brown has been put in the chat already that you remembered, I think, almost verbatim. So, and there were
I wrote it down.
a couple of other choice ones as well. They're asking us to start our video, so here we are. Well, thank you all. This has been just fascinating. I'll just give you a quick 30-second reflection. I have a couple of specific questions and give people a chance to put some questions in the chat. I see there's already one or two in there. But I think we started with a little bit of a description from Mary S. about how we got the corporate model, the municipal model that we landed up with in 1867, and what was going on and what was frozen. I think you used the word frozen in that moment, but that was otherwise sort of a plus échange moment, I think is what you were suggesting. And then a little bit later, we heard Jean-Christophe informing us a little bit more about the struggle that was going on in the constitutional principles that inspired or were somehow in the discourse of the day when the 1867 moment came around. And a part of that was the fiscal realities, the taxation without representation, the story of the money. And then we heard a little bit about the rise and fall of the story of municipal finances. I keep seeing these graphs where we have a peak in the 1930s, in the early Depression moment, where there's a lot of debt and I guess a lot of revenues being raised as well. And I wanted to ask a little bit about the composition over time. But then it tails off. And I think in the chat we heard that, and of course now we have very much harder restrictions on municipal debt. And so we aren't able to see the same kind of rise and fall if we're trying to draw lessons from the past. But I'll get to that in a second, Almos. And then we had it all articulated better than I ever could hope to by Mary into a set of Supreme Court submissions, urging them to see the reality of the historical record, even though it can be fresh and still undeveloped, and a little bit Canada Westish and not enough Canada Eastish, but to see the narrative of what was going on then, that there was some form of thriving municipal democracy. In fact, it brings back, it makes me recall the mention of Engen Eisen's book in the previous session, and the sort of simultaneous fear of local democracy, but necessity of it in the development of the urban infrastructure of the day. And even the word infrastructure is very provocative and suggestive today as we face the post-COVID exact same set of claims, and how are they going to be paid for, and so forth. So there's just a little summary of what I thought we heard, and I'll invite all my panelists to correct me in the things that I've mischaracterized in their argument. In a second, I'm going to ask Mary Stokes. I hope she's there. I don't see her on the video in a second. In a second, I want to ask her a very specific question about the freezing moment. But one of the first questions I see in the chat here, and it looks like more than one person that wants to have it asked. So we'll let you lead it off. Since you're, and Jean-Christophe, I'm just going to make a bunch of assumptions. Since you're the junior member of the bar here, we're going to ask you to go first and give your reactions and reflections on Mary's presentation just now, because they really do seem to speak right to each other. And I'd love to know, and I think a few other people in the group would love to know your thoughts immediately. And then I'll come back to Mary with Mary Stokes with a question I have about the formation of the, you called it a sui generis model of the corporate form in Ontario anyway. And I want to ask you about something as compared to the US. So let me get out of the way, and Jean-Christophe, if you would reflect.
Yeah, thanks for that question. I was actually thinking about that because I listened to the oral argument 2 weeks ago, and I was really interested in seeing how the history would be drawn upon to make these kind of claims. It was really interesting. But I think there are two ways of seeing this, let's say the Durham vision, and one of which is the liberal picture. And the liberal picture is that you need to have local democracy for an inner transformation of the British subjects. They're going to be good self-governing people if they learn how to self-govern through small-scale local institutions, and then they can go up the ladder to a bigger institution. And I think that this was the gist of the argument, at least that Mary's team was pushing at the Supreme Court, to say that local democracy was crucial pre-Confederation era. But I think there's a different kind of story, which is more Machiavellian, one might say, which is you don't need to have this kind of inner transformation. And that's not necessarily what municipal institutions are doing. Municipal institutions take members of the assembly as rational, self-interested individuals. And if they do this, they're going to cater for their local constituents and not pay enough attention to kind of the general public. And thus it will impede the formation of kind of political parties. So to have these kind of political parties, you need to address, institutionally speaking, the problems of pork barrel politics, log rolling, etc. And if you don't do this, you won't have political parties, or you won't have as strong political parties as you would need for responsible government to function properly. So I think these are kind of, they go in the same direction, and Durham says both things. I think he's having two kinds of conversation at the same time, but the Machiavellian dimension is also present. And that's what I call the constitutional dimension. So I would say it's constitutionalized in section 54 that already says that money bills have to be introduced by the crown. Municipalities is just in the background.
Mary, do you have a quick response to that, or do you want me to give you a bit of breathing room because you've just spoken?
No, I'm very interested in the observations about the two, at least the two ways that one can see Lord Durham's report. And I happily admit that we were going for the Tocqueville version of the liberal democratic dream. And, you know, because it actually provides more support for the argument that a respect for civic democracy is crystallized or held in 92.8. I think probably dealing with the other arguments is something that we're going to do in the paper that arises from this presentation, just so that we are sure that we've answered your concerns. And the paper that you provided before today sets some of them out. Of course, you may be receiving phone calls from us as well, just to further our education in your arguments. I was very interested in what you had to say and hope that we can take it into account when we render our factum into an article.
Thank you, Mary. I'm going to just ask, I don't know who might have technical staff abilities here that are well beyond my own, but I fear Mary Stokes has been blocked out, but I'll bring Mary. So Mary, I'll hold your question that I have for you in a second, and I'll ask Almos to weigh in on something that I just am it's not really a question, but I'm drawing it from some of the chat, especially the earlier chat when you were speaking. There was, well, reflecting on what you were saying about especially what I have been calling the rise and fall, the expansion of municipal finance, debt, and revenues up until at least the 1930s. And I think you were saying, and correct me if I'm wrong, the use of them, particularly for infrastructure projects post-World War I, and other things, which all faded away, I guess, during the end of the Depression and the beginning of the war. A couple of questions come up in that context. One was, well, what is the capacity by comparison to the present, since the constitutional order was already in place? What is the capacity to relive a moment like that, especially given post-COVID and kind of Green New Deal talk about the way to have a locally controlled and democratic process in the way that Jean-Christophe has been highlighting attention around? Is there municipal capacity to do this anymore? Does something have to be fixed? And then the second thing is just a sort of an interesting reflection. I'm a labor lawyer primarily, and one of the debates we've had sometimes is about minimum standards across a province, which is always full of holes, and it's a patchwork in many ways. But one of the arguments against something that's proposed occasionally, that where we have strong activist presence in municipalities, that we permit there to be a different minimum standard for wages and conditions of work in, let's say, Windsor or Kingston or something like that, than there would be in Toronto, that we should do that. And this has been something that's been done in the United States, for example. You've had an attempt to do ratcheting effect by having a very good minimum standard in San Francisco and hope it'll get adopted in the rest of the municipalities in California. The argument against that is it's a race to the bottom, not a race to the top. And you mentioned, the reason I'm drawing the comparison, and I'm taking a bit of time to get there, is that you said that there was a patchwork problem, particularly with the income tax revenues being generated across Ontario. And is there still a danger of those kinds of things happening if we were to have a modern kind of reinflation of municipal finance as a primary source of funding of some of these projects? So sorry, that was a very long-winded way to ask the question. Let me get out of your way.
There's an awful lot in those questions that you're asking. I might, if I might have your 30-second indulgent on the 18 and what's been pointed out to me by Richard Bird, and also work which is in the doctoral dissertation, and is there's a lot of path dependency, if I could put it that way. And this is maybe a little bit of I'm thinking my way through this thicket, but the thing is that the arrangements that were there in the 1850s and 60s, I mean, the interesting thing is how much path dependency there is in terms of the carrying on of some of the institutional structure, some of the tax arrangements. There were obvious changes, but the one thing that occurred to me here, which is interesting and it has not been mentioned, was that there was a fiscal crisis that Michael Piva writes about in the period that's been under discussion by Mary and Jean-Christophe. And the interesting thing is, in fact, was that the Canada West, or Francis Hincks, turned to the municipalities, the municipal capacity and the municipal capacity to tax for what it was worth, to borrow and to essentially bail out the senior government. But also at the same time, I mean, in writing that I co-wrote with Richard Bird when we were first looking at the whole issue of soft and hard budget constraints over time, the interesting thing was that investors were very aware of, you know, what the implications were in the financial markets of these various borrowing schemes. Now these issues don't go away, and they come back in a slightly different fashion in some ways later. So to go back to your other question about those trend lines, I mean, one of the things that I was at pains in constructing these trend lines was to actually show that the hokey numbers on which they're based, as Mary will say, from the sessional papers, at least I wouldn't want to swear to the actual dollar amounts as an economist, but the trend lines fit with which are reasonably good on the whole issues around capital formation, to answer your infrastructure question. I mean, by the 1880s, 90s, the Victorian city, the pre-World War I, you have, you know, serious efforts at water supply, at sewer works, at roads, and again, there's a huge American literature on the implications for urban health and for the other things. And as Lou Kane pointed out to me when I was working on this, so the other big infrastructure thing was building secondary schools, and so we lose track of the competition for the more easily collectible real property tax base as opposed to the income tax. This is really a broad brush answer to your question, and the question on that was raised in the quote that you're relaying back to me and that I found was the dissatisfaction internally with municipal income taxes essentially was its administrative and functional wherewithal. In some sense, if we went that way, given modern methods, we have less problem that way. In that's not really answering your up and down question. I'll come back to that in a minute. But I mean, in terms of a checkerboard minimum standards today, the information systems and so forth, you can this becomes a choice of how you design a tax system. And I plead guilty. I was working at the province in the midst of the property tax reforms in the 1990s. So at a separate other point, we'll talk about binder wire, checkerboard, and practices. And the whole issues around the kinds of assessment system which had to be reformed and moved through and issues and so forth. Those are well beyond today's discussion, but they're a very good question, because they do relate to in a sense, you know, if you start to move away, like what size, what capacity, what are the local capacities? They are so different in terms of a Toronto or upper tiers and lower tiers, and the county and the county system versus separated cities, and all of the modern variants on authority, capacity, and so forth, which are all the questions that anybody looking at alternative revenue sources, or even the paper that Mary Janigan is presenting later today on equalization questions. I mean, as a former victim writing briefing notes, some of those things just leave me cold as an issue of how you'd ever get to the design. So your questions are spot on. But to answer the peaking question, I mean, what I was really trying to show there was that you had essentially the capacity to try to raise revenues, and the base seemed to be supporting it, although there are inequities and other issues that I completely skipped here, that others will hang me out to dry on, the exemptions within the system, the bonusing that was going on for manufacturing in the 1890s, and the province mashing that to bits, the 1904 business tax reforms. But what's quite clear is to get to your last point, the peak that happened in the 1930s, essentially, to my mind, it's buttressed in two other chapters in my thesis, is that we hit a tax wall in the 1930s there. There was effective resistance to effective tax rates and the property tax system going about 4 to 6%. This is a quick answer to your question. And at that point, then the province had to others stepped in. Some 30 municipalities went bankrupt. They couldn't pay their debts. Some of those were debts predicated on the idea that suburbs would be built, that tax capacity would be built. So this is the quick answer. We'll have an off-book conversation about this later.
All right,
but essentially, that's what happens in that point. There was a wall, and if you want the last answer to your last question,
I have to ask you to wrap up, Almos.
That's it. I've written there's a short memo I've written, and it's on the CDHOW website.
Okay.
Municipalities are not overborrowed at the moment compared to the 1930s.
Thank you, Almos. And I will ask all the panelists to send us links to any of the things you've been talking about today. Mary Stokes, I'm very sorry that I unfairly locked you out of the Q&A. Do you want to have the last word? You can reflect on anything that's been said on the panel so far. Have the last word. Take the next 60 seconds.
Oh, there is a question here about, is there anything that limits the ability of the province to delegate to the municipalities?
Yep.
And the answer is, as long as it's within the provincial ambit, they can do that. And what they do now is they download responsibilities, that has been a change from the way it started. Whereas it started that municipalities had all the responsibilities because they had all the money, and they were doing all of the work. They had the bureaucrats working for them. The province had nobody in the provincial service. Hodgetts has written a lot about this. But every county had to have a treasurer. Every county had to have a clerk. And the province just gave these people things to do. They weren't paying them themselves. The localities were paying. So it's a little.
Thank you, Mary. I'm very sorry. I have to cut you off, and
No.
I let's take it offline and continue the conversation. Or maybe
Fine.
Mary Eberts will have convinced the court to say something about that last question. We don't know yet. Thank you all for coming and your participation today. Very much appreciate it, and your patience with me moderating. I think it's time to sign off and get a coffee before the next panel. We'll see you there.
Thanks a lot, Simon.
Thank you
Thanks
again.
very much, Simon.
Bye bye now.
Bye. Thank you all.